How far did you get in school?
I have a college degree, neuroscience, neurochemistry.
Make a decision to waive counsel and represent yourself.
Policies on behalf of the people.
Josh Lindell on behalf of Mr. Chiarelli, who appears with us in custody.
All right, we are scheduled for, so I set this for a pretrial conference. The first time we set it for the pretrial conference, there was a whole bunch of other things ended up happening, so I didn't get my checklist together. So I want to make sure that we have everything set, okay? So you're scheduled for trial on July 21st. Are the people announcing ready?
We are, Your Honor.
Mr. Lindell, on behalf of the defendant, are you ready to proceed?
Yes, Your Honor. Mr. Chiarelli has indicated he would prefer to go pro se at this time. He does not wish to waive his speedy rights, but he does wish to continue pro se.
Mr. Chiarelli.
Yes, Your Honor.
I mean, can you get me an agreeable advisement?
Yes.
It is obviously your right to go pro se, but I will tell you that you don't have any legal training. This is not like what you see on TV. This is actually really hard work.
I understand. I understand this very, very much so. I don't actually want to do this at all. I have extreme concerns with my breakdown in communication with my attorney, and my want is not to go pro se, but my want is to be actually capable in assisting in my own defense.
What does that mean?
Communication. I have had no actual visits from my attorney leading up to trial. The first time that I've seen my attorney in the last 2 months has been for less than 20 minutes in preparation for trial. Our actual legal strategy that we talked about for less than 20 minutes. As far as a capable client who is capable and knows his own rights and has been cleared as somebody who is not only by the courts found competent and able to assist in his own defense. If my attorney cannot strategize with me and is not capable of finding the time to go over strategy with me of what we are going to do in trial, then I would rather blunder through trial by myself.
Okay, listen,
as much as I am capable of, because
okay.
My freedom is on the line here.
Okay,
and I know.
Okay, I recognize that, Mr. Chiarelli. I will tell you that, as I'm sure you can imagine, Mr. Lindell has multiple cases and many, many other clients. And so I know that you've indicated that he hasn't, that he's seen you for 20 minutes. Based on Mr. Lindell and what he did at your motions hearing, that I'm confident that he's familiar with the facts of your case. He's familiar with what your arguments are, and he's familiar with how to proceed in trial. But it's not simply the facts that matter when you go to trial. What matters is all of the other legal aspects of the case that make it difficult for someone who is pro se to know what they're doing.
Absolutely.
You understand? And the reason I'm saying this to you is because, just one small example is when you're selecting a jury is not just a matter of picking a bunch of people out of a hat. There's a process to it. There's strategies to it. And these are things that you don't know how to do. And Mr. Lindell is familiar with the way the process works.
100%. I understand this. And I respect this part of the legal process that I am not currently empowered in my education to the standard that Mr. Lindell is. Like I said, this is not my chief want, but I have a issue where, just recently, Mr. Lindell and I are trying to communicate, where he's trying to communicate with Mr. Aziz and I, where Mr. Aziz is trying to communicate about a possible plea agreement between me, Mr. Aziz, and Mr. Lindell. And even the communication back and forth to us, I can't get Mr. Lindell to actually communicate my words to Mr. Aziz and I. He wants to argue with me rather than, he gets angry with me rather than actually communicate. When I say, could you go tell him this? No, I'm angry with you and you're gonna talk to, and it's just like, okay, well then can we talk to Mr. Aziz and you and I together? No, that makes no sense to Mr. Lindell.
I think Mr. Chiarelli, upon that further record, is requesting a burger root hearing rather than to proceed pro se.
I can't do that though, because I cannot, unless we can do that within the frame of speedy trial.
No one, we can't,
Right.
and his speedy runs like soon.
And we've already run over Speedy. Honestly, we've already
No, we didn't
extended,
run over
well, because Speedy was supposed to be, I think, the 7th originally. We've already, we've already extended past Speedy twice, actually, when we told it the first time, and then we went to the 21st when it was supposed to be the 11th originally. So, from a defendant standpoint, who might not know the legal process, but knows his rights very well from the National Assembly, a federal, state, and sovereign citizen right. I know my rights. Those are things that I know very well. And, from my standpoint, I can't. I love a burger hearing, but this is why I pressed it after preliminary hearing and tried to get in front of a burger court from that point, because from the point of preliminary hearing on, I've asked for burger hearings.
Well,
I couldn't get in front of them. I just can't.
Based on what you're saying anyway, it's unlikely that anyone would, any of the other judicial officers would appoint you another attorney
Right.
based on the record that you've made today. But before accepting your decision to waive representation by an attorney and allowing you to proceed without an attorney, I need to advise you of the effect and the consequence of your decisions, okay?
Yes, ma'am.
But I'm gonna ask you some questions to which I'm gonna record your responses, and then I will have you sign this document, okay?
Okay.
Now, hold on one second. A criminally accused enjoys the constitutional right of self-representation under the United States Constitution, Colorado Constitution, and the Colorado Constitution. The right of self-representation is personal to the defendant and may not be abridged by compelling the defendant to accept a lawyer when he or she wishes to represent him or herself, and that's under People versus Romero. 694 P. 2nd, 1256 Colorado, 1985. Now, Mr. Chiarelli, do you read, write, and understand the English language?
I do.
Do you understand that you have the right to be represented by counsel throughout these proceedings?
Yes, Your Honor, I do.
Do you understand that if you cannot afford an attorney, that one will be provided to you free of charge if you qualify for the appointment of state-funded counsel under JDF 0404?
I understand the basis, not the statute.
You understand that if you can't afford an attorney, you would be entitled to an attorney, which is part of the reason why you have the public defender's office representing you.
Okay, so like I said, I understand the basis of it's
Yeah,
possible
okay.
representation.
Do you understand that I will appoint counsel to you if you want an attorney, but you have an attorney and you just don't want that attorney, so you know that.
So this question, like I said, this is coming about from maybe something that I misunderstood, because the actual conversation that I had with Mr. Lindell was, he was talking to me about a possible plea agreement that Mr. Aziz had offered him. And Mr. Lindell got frustrated with me, and I said, well, could I possibly just speak to Mr. Aziz about this? Because maybe I'm not communicating right with you. And he said, well, shit, you just want to represent yourself then? And I said,
Okay, I don't know, Mr. Aziz, are you here by yourself
Yes,
for the rest of the afternoon?
I am anticipating that, yes.
I don't, look, Mr. Chiarelli, the long and short of it is, it sounds like what you're saying is that Mr. Lindell was getting frustrated with you, and as a result, you feel like
that's how it got communicated that I wanted to
Okay.
represent myself, because I wasn't telling him I want to
but you
represent
don't
myself.
want to represent yourself.
I wasn't necessarily communicating that. I was communicating that I would like to talk to possibly him and Mr. Aziz. And then it got to, well, I'm just going to tell the judge you want to represent yourself. And I was like, okay, I guess that's where we're at then. I don't know.
Your Honor, if Mr. Lindell and I can coordinate, maybe outside a docket, having a further conversation, and we can add on if something changes.
Are you available this afternoon to have a conversation with Mr. Aziz? Are you available?
I mean, other than being in here.
I know, but I'm talking about like, it's 1:20.
Yes, I have two cases at 1:30. I believe it's two cases at 1:30 and that.
Well, I meant like
Yeah,
3 o'clock,
as soon as that's done.
as soon as it's done. Are you here for the rest of the afternoon by,
Yes.
we'll be done by 3.
Okay.
Okay? Why don't we continue to go through the pretrial conference stuff? And then,
Your Honor, could we maybe take up pretrial next Monday?
I am in trial.
Okay.
I'm in a
I'm out
homicide
for
trial
next
for the
week.
next 2 weeks.
Understood.
So, and then, I have a different judicial officer here for your trial, so I'm not gonna be the one presiding over your trial. So what I'm gonna do is, this is what I'm gonna do. You guys can talk about this a little bit later, and if you want to keep Mr. Lindell, great. If you don't, I'm gonna go ahead and I'm gonna go over the advisement with you just in case you decide that you don't want him. Now, if you want any other attorney that you can hire on your own, that'll be fine, but keep in consideration that no attorney will be ready to go on July 21st. All right?
Right.
Now, so you understand that, so I still have to ask you these questions so I can go through this advisement, okay? Do you understand that I will appoint counsel if you want an attorney to represent you, if you qualify for the appointment of state-funded counsel, which you have, all right? So you understand that?
Yes.
Okay. What are the these are the charges against you. You have, one charge of aggravated robbery. Or excuse me, hold on 1 second. We have one charge of criminal attempt to commit aggravated robbery pursuant to, that's a class 4 felony. And that's under 18-4302 subsection 1B and 18-2101. A class 4, for a class 4 felony, you're facing between 2 years and 6 years in the Department of Corrections with the mandatory period of parole of 3 years, okay? And then, hold on 1 second. 2 years to 6 years DOC and 3 years parole. And then you're facing count 2, which is second-degree assault. For that, you're also facing between 2 years and 6 years in the Department of Corrections with mandatory period of parole of 3 years. You're facing, actually, you have 3 counts of second-degree assault, so you're facing that for all 3 of those as well. You also have 1 count of criminal attempt to commit assault in the second degree. That's a class 5 felony. You're facing between 1 year and 3 years in the Department of Corrections and mandatory period of parole of 2 years. And then you have 2 counts of menacing, which are both class 5 felonies, and you're facing between 1 year and 3 years in the Department of Corrections and 2-year mandatory period of parole. Is there any aggravation here?
Yes.
I will say that the defendant is subject to the 2 prior felony rule. He was pending a felony out of Broomfield at the time of arrest, so he would be enhanced.
So he would be looking at, on the class 4, he'd be looking from 4 to 12?
Yes, Your Honor.
So on all of those count 4s, on all of those class 4 felonies, which are the attempt to commit aggravated robbery, the 3 counts of second-degree assault, you're actually facing between 4 years and 12 years in the Department of Corrections, all right? With the mandatory period of parole of 3 years. On the class 5 felony, you're facing between 2 years and 6 years with the mandatory period parole of 2 years. And those are for counts 5, attempted second-degree assault, and the 2 counts of menacing. All right? Do you understand that?
I understand.
Okay.
Clarify just on those assault 2 charges, they have the different sentencing scheme. It's 5 to 16 instead of 4 to 12. Well, that's the presumptive range.
5 to 16, not the 4 to. It's not midway through the presumptive?
I think because they're officer assaults, it's 4 to 12.
So there are,
Charge to assault cause injury with a deadly weapon.
so all 3 of these are, oh no, so Larry Smith is not an officer, but Grunther and Rembert are officers.
Yes, they testify.
So on count 2, he'd be facing between 5 to 16.
Yes.
And then on count 3, 4 to 12, count 4, 4 to 12, count 5, you're facing between 2 to 6, count 6, 2 to 6.
I think it would be 1 to 6, Your Honor. For count 5.
Count 5, oh, the attempted assault, 1 to 6,
Yes, Your Honor.
and then the 2 menacings.
1 to 6 on both.
That's a jury laughing before they. All right, and then, excuse me. Do you understand that? Those charges against you? So you see that you're facing up to 16 years on that count 2, and then the rest of them,
That's
I've
right.
indicated what you're facing, right?
Mhm.
Okay. Do you have any legal training?
No, Your Honor, I don't, not in this.
How far did you get in school?
I have a college degree, neuroscience, neurochemistry.
Make a decision to waive counsel and represent yourself.
Like I said, I wasn't necessarily, I was just asking if maybe I could speak to Mr. Aziz for a moment, that's all.
Which you will
I
do.
wasn't trying to necessarily say that I wanted to cut my counsel or represent myself fully. I was just thinking that maybe I could communicate directly what I was having a hard time communicating indirectly to Mr. Lindell if I had just a moment to speak to Mr. Aziz with Mr. Lindell, or directly to between the two or three of us, you know? That's what my suggestion was when I think Mr. Lindell got a little frustrated with me and wrote, okay, so you just want to go pro se. I wasn't trying to suggest that I'll just go pro se, but if I have to, then so be it, was, you know, my line of the reasoning. So I'm not, you know, that wasn't what I was necessarily trying to do, but if I have to, then I will, yes.
Okay.
I just,
So the question that I asked you though is, do you wish to consult with the public defender before you make a decision as to whether or not to waive counsel and represent yourself?
I don't really wish to waive counsel or represent myself, honestly.
Okay. All right. So then what I'm gonna do is I'm gonna pause this right now. I'm gonna hold on to this paperwork. You guys can talk later, and what we'll meet on I'll have a different judicial officer advise you on Friday at 8:30, okay?
Okay,
If you reach an agreement, great. You'll be in front of Judge Bland probably on Friday.
okay,
So she'll make the decision as to whether or not you have waived your right to counsel and how you plan to move forward.
okay.
All right?
All right, thank you.